Hi, everybody. Thanks so much for joining NA's webinar for May 2025. We really appreciate everybody being here live and for folks that are watching it after the fact, too. So welcome. Just a little bit of housekeeping and then some introductions before I hand it over to Robert. My name is Charlie Culpepper. I'm with, of course, National Aquaculture Association. I'm the Director of Membership and Public Outreach for NAA. Everyone is going to be video off and muted right now, but the chat box is working. So if you come into any questions at all during the presentation, feel free to type those in the chat box and I'll get to them during the Q&A. Robert has about a 30-minute presentation, and then we'll just kind of have an open discussion. And once we get to the Q&A, you can also use the raise your hand feature, and we're happy to unmute you, and you can speak up then anytime. So look forward to a really good discussion today. Before I get started, all of our NAA webinars are sponsored. We really appreciate folks providing a little bit of extra funding to help us with these. So this month, Gulfstream Aquaculture, which is owned and operated by Dennis Peters out of Miramar Beach, Florida, sponsored our webinar. Gulfstream Aquaculture focuses on marine finfish research and development, coastal, offshore, land-based siting analysis, demonstration, pilot farm operations, and commercial feasibility assessments for land-based and ocean aquaculture. They have a ton of experience, and we really appreciate Dennis, again, sponsoring our webinar this month. And with that, I want to also give you a little bit of background on Robert Smith. He's our returning webinar champion. Hopefully you've got to catch his presentation from last fall as well. So this is kind of a little two-part follow-up from Robert, who works at K&L Gates. They are a global law firm with over 20 offices in the United States. Robert's a member of the of the firm's Environment, Land, and Natural Resource Practice Group. His practice focuses on land use, governmental and regulatory permitting, shoreline development, and aquaculture. He's assisted dozens of companies in obtaining local, state, federal permits and license, lobbied on behalf of the aquaculture industry for legislative, regulatory, and policy initiatives, and defended aquaculture companies in litigation and enforcement actions brought by private parties and regulatory agencies. He currently splits his time between Seattle, Washington, and California, and spends his free time hiking in the mountains, camping, and skiing. So, Robert, again, we really appreciate your time. It's always awesome to have, aquaculture attorneys on board. We really appreciate your expertise, and it's always a fascinating presentation. So, welcome back, and I will hand it over to you to start off the presentation.
Hi, everyone. Good morning, good afternoon. Thanks, Charlie, for that introduction. So as Charlie mentioned, this is the second part of a two-part series. Builds off of a presentation that I did at the Aquaculture America a couple of years ago. The first part of that series talked about sort of strategic thinking about how to develop a successful permitting process for aquaculture projects. So that really dealt with before you submit an application, going through the application process with your local, state, and federal agencies, and how to develop a process and a protocol that hopefully drives you towards a successful permitting decision. The second part of the series really talks about, hopefully that first part went well, but regardless of how well it went, and if you've got an approval, even if you do that successfully, there's also always opportunities that somebody might challenge your project through administrative appeals or through litigation. So this second part will talk about how to develop a successful litigation strategy and how to defend litigation. I'll also talk a little bit near the end about the flip side of that coin, assuming you did not get your approval through an appropriate administrative agency, how you go about challenging that decision. And then related to that, because it has been such a topic of interest, I'll be touching a little bit on the Loper-Bright decision and how that plays in litigation concerning administrative approvals and litigation in the aquaculture industry. So this is a slide that I talked about in our first part of the series, but I wanted to bring it back up because it really influences how you defend a permit in litigation. But it happens before your permit is issued. It's really critical to create and defend your administrative record. Most cases that challenge aquaculture permits rely upon the administrative record that was before the administrative agency. So in other words, unlike if you had a tort or contractual claim where there could be discovery, there could be additional experts, there could be other things that are presented to a court or a court of appeals. In most of the cases that challenge aquaculture permits, you're really going to be limited to what was before the administrative agency at the time of the approval itself. So it's really important that you defend that that you create that administrative record before that permit is issued or denied. Oftentimes there's a lot of times I've been asked to come in as litigation counsel after the permit process has happened. And a lot of times you sort of feel like you're fighting with one arm behind your back because a lot of the things you wish were in that evidence, that administrative record as evidence, aren't actually there or were developed too late to be before the court in the litigation. And so it's really important to be thinking about these things before your permit is issued. So what things can you do to sort of supplement that administrative record? First, it's really critical to use experts where needed to fill in information gaps, to provide the best science available to the administrative agency. Don't necessarily just rely upon the administrative agency's expertise in developing that. Second, engage in environmental review, even if it is prepared by the regulatory agency. So in most cases, your environmental review, whether you're before NIMS or a local estate agency, they'll need to conduct some sort of environmental review through that process. But you should, or it's preferable to hire your own environmental consultants to at least supplement that record and provide additional information where appropriate. Because really, while many administrative agencies can be really good subject matter experts in some of the environmental issues involved, they don't know your company nearly as well as you do. And so having an environmental consultant on board that can sort of translate your operational details and really what your farm is going to do specifically and evaluate those environmental impacts is really critical to defending that record if it is subject to litigation at a later date. Another key issue is to try to figure out what level of environmental review is going to be appropriate. So at the federal level, this is usually done under the National Environmental Policy Act, or NEPA. And that will look at whether you want an EA or an environmental assessment or an EIS, an environmental impact statement. A lot of times an EA will be appropriate for aquaculture projects, but we have seen for some larger projects or very controversial ones. So for example, if you're looking at offshore aquaculture, where NOAA is preparing a full EIS. The same level of review is generally applicable to state agencies that will have a more cursory environmental review or the more robust one. On a whole, as you look at these issues nationally, at the end of the day, an EIS or the same level of environmental review at the state level tends to get more deference before courts because there is a more significant and thorough level of environmental review. But also that comes with additional cost and time delays as the federal or state agencies prepare that environmental analysis. So it's really important to figure out early on how controversial is a project, how likely is it to be litigated, and therefore that will drive your discussion with the state and federal agencies as to whether it's appropriate to do a more robust environmental analysis that may be a little more legally defensible, as opposed to a more cursory one, which will get you through the process a little bit quicker. Obviously, you also have to look at those triggers as to what would trigger an EIS or a similar state document. So, for example, are there going to be significant and unavoidable environmental impacts from your project? And there are certainly some circumstances where those have been determined to be unavoidable impacts in previous projects. And the last one I'll say about the administrative record is usually the lead agency will be required, the public agency will be required to respond to public comments, but make sure that you are also responding to public comments, especially comments in opposition that are submitted during the public comment process. Again, you know your project better than anyone, and providing that level of detail in a respectful way and responding to comments that come in respectfully and not too defensively, but making sure that the science and your project are considered accurately is going to be really critical to developing that administrative record. So fast forward now, you've gotten your permit approval and there's a possible risk of litigation. One thing that's going to be really critical is to figure out, what that litigation risk is before even the litigation starts. So some things to really think about as you're moving through the project. Do you have sufficient funding in order to defend a litigation claim? Obviously, lawyers are expensive, and going through a full bout of litigation, which can take multiple years, is not an inexpensive process. And so trying to figure out whether or not you have sufficient funding, not just to develop the operation of your farm, but also to be litigation ready, is critical when you're actually doing your financial calculations, projections for a project, especially if it's going to be controversial. Secondly, do you have agency support? This may be an obvious one if you say, well, of course, they approved the project. But it's fundamental to understand how supportive the agency is going to be during the process. Just simply because they approved it does not necessarily mean that they're going to necessarily go to bat and be an active player in litigation if and when you are subject to a litigation claim. Third, what is your farm schedule? That's critical because litigation can, again, take years to wind its way through the court process, particularly if there's going to be an appeal. So understanding how those litigation risks will affect your operational and farm schedule and pre-planning for that possibility is really important. And then finally, trying to work with your legal counsel to understand is there a risk of a stay or injunction? Your litigation risk and your impact to your farm is going to be far less impactful if you can avoid a stay or an injunction that would prohibit you from moving forward with the implementation and operation of your farm, as opposed to where you have to put everything on pause while everything winds its way through the court system. So I'm going to walk through, I think, just sort of 6 general tips for a successful litigation strategy. Obviously, this is a national presentation, so some of these may vary from region to region. But so these things that we've seen as being successful, sort of as general strategies for litigation throughout the country. One of the most important ones is to find success in what you're trying to achieve in litigation. And that's an important first step because, most people will just say, well, obviously we just want to win. But that may not, defining what a win means may be really important. That may not actually mean going through the entire process to actually win the litigation itself. It may be that you want to do that, but there might be other wins along the way that actually put you at a better chance for ultimate success of your farm. So the first one is that you should work with your legal counsel to define as best as can be done, the evaluation of the legal costs and operational costs of going through litigation versus the actual damages associated with a litigation claim. So most lawyers will be able to give you a general range of what the litigation can cost. It won't be an exact number usually, but they can provide a general idea of what that would look like. At the end of the day, if it's going to cost you, just throwing out numbers, $50,000 to settle and $200,000 to go through the entire litigation process, then that's at least a factor in determining whether or not you want to go through the entire process to the end versus do a relatively quick settlement. Trying to identify injunctive relief or mitigation. What are they looking for? They being the opponents in the litigation. So, for example, are they looking to simply kill your farm, as in that there's nothing that they will accept as an acceptable operation and farm location? Or are there some things around the edges where those be additional conditions of approval or mitigation measures or maybe an alternative site that would be acceptable that are in consideration? So understanding, what those permutations may be are going to be really critical to whether or not there could be a potential settlement before going through the entire litigation process. And that sort of feeds into the next part, sort of know your opposing party. So usually when we are working with a opposing party we don't know well, we'll do some background research to see, okay, how many times have they litigated before? How many of those have resulted in a settlement? How many of those have resulted in a published decision? How many times has that published decision been appealed? and how many times have they been successful in that overall process. So the more you know about how the opposing party sort of navigates their own litigation strategies will give you an idea about how to best sort of engage in settlement discussions or an overall litigation strategy to defend against that opponent. So, for example, there are some opponents that we've worked against in the aquaculture industry that are fairly well known that, they've settled about 60% of their cases. So they use litigation as a tool for them to hopefully overall settle the case. And in those cases, there is a pretty good chance that maybe we can reach a settlement that works for both parties. Of course, there's other ones that are well known in the industry that they don't want to see any aquaculture developed, or at least what they consider to be quote unquote industrial aquaculture. In those cases, your chances of settlement are prohibitively low, and you have to sort of be dug in for a longer litigation battle. So finally, also understand the potential impact to your farm and operations. Is your farm going to, and the financing associated with it, be really significantly impacted if you go through, 2 years of litigation and ultimately succeed, but you're now 2 years behind your schedule? Or is it more important to try to find a quick settlement that even maybe in the short run may be somewhat, not ideal, but in the long run will allow you to cultivate much more quickly? And the last one here, if you're a frequent player in the aquaculture industry, you always have to think about precedent. Is this going to be an issue where it may come up again and you actually want to establish beneficial legal precedent that you may be able to use in future cases, particularly possibly against the same opponents? So just talked about it, but again, the administrative record is key. It is unlikely that you're going to be able to add a significant amount of additional analysis and detail in most of these cases after the decision has been made by the administrative agency. So making sure that your science is well developed, that your analysis is well supported and well supports the agency's position and determination in the case is going to be really critical. And also making sure that as the administrative record is developed, that you are coordinating with whoever is developing that to make sure it's done properly. And that sort of gets to the next point about coordination with the agency. In most of these cases, the administrative agency is going to be the technical defendant. In other words, they are the party that issued the approval, and so they are the named party in the litigation. And so you aren't necessarily, in most states, by right, added to the litigation. So there's two things about that. First, make sure you're coordinating with the agency from day one when they are subject to litigation. So making sure that they're representing your interests, that they understand the legal issues and other issues, operational issues that are at stake. And that hopefully your interests are aligned in that process. So executing something called a joint defense agreement that more or less allows you to work with the agencies in a confidential manner as if you were co-defendants is going to be really critical. But you need to make sure that your interests are aligned throughout that process and don't necessarily assume that they are. I mean, in a lot of cases, I sort of compare, the administrative agency to sort of like if you get into an accident and your insurer is representing you. The insurer has their interests as well. And while your interests may sort of be aligned, that you want the best, outcome, but there might be differences between what they consider the best outcome versus what you consider to be the best outcome. The same can be true for agencies as well. The agencies have their own considerations at stake in litigation that hopefully are aligned, but maybe slightly different than yours. And for that reason, make sure you're engaged. In a lot of cases, you'll want to seek to intervene in the litigation. That means that you basically come in as a real party in interest, and that allows you as the company and the party that's really mostly directly affected by litigation to represent your own interests in the case. And so a lot of times, while that will cost more money to you, but it allows you to be an active player in the litigation, have your own say in court, as opposed to relying upon the administrative agency to do so, which a lot of times is beneficial for the court to hear from both the agency's perspective and the affected company. Then also participate in the development of that administrative record. So in most cases, the agency itself will be the one that gathers most of the information that was before the agency at that time. But you want to make sure before that goes to the court that it's reviewed, that it's comprehensive, that it includes everything possible that could have been before the agency that could support your decision making. So a good example is, I was just on a call about this morning, where we're reviewing an administrative record that cited, a bunch of communications from the company that we represent in the case, but didn't, at least the draft from the agency didn't have all the underlying studies that were cited in that communication, which are going to be really important for a court to potentially review. So make sure that that administrative record is as complete as possible and sufficiently represents your interests in the litigation. The next is consider procedural issues. So there's a couple of procedural issues that come up a lot in appeals of administrative decisions that can be an easy win if the petitioners have not met what they need for to be procedurally before the court. So, for example, in Clean Water Act cases, they need to file a 60-day notice before they actually bring a suit in court. Have they complied with that? Have they exhausted administrative remedies? So in a variety of administrative decisions, especially if you're looking at state and local approvals, there will usually be an administrative decision, and then there will be a lot of times an administrative appeal option. And in almost all cases, they can't simply just get the decision, the initial decision goes straight to court. Usually there is an administrative appeal step before you get what's called a final agency decision that could then therefore be appealed. So make sure they're not sort of hopscotching over those other administrative appeal options, because that would mean that they haven't appropriately exhausted their administrative remedies. Another critical one is standing. And this is an issue that I think we're probably going to get some guidance from the Supreme Court this year. Usually, at least in past precedent, it's been fairly easy for a variety of environmental NGOs to establish standing, either by saying that they have community members that enjoy the environment or are vitally invested in the ecology of the region or the water body that you're looking to develop in, or they have recreational uses that support those interests. The Supreme Court is taking a little bit more of a closer view at that in the last couple of decisions that they've looked at. So there may be some limiting of how easy it is to establish standing for environmental organizations. And so that's something to sort of keep an eye on as to whether or not there's an argument that particularly an environmental NGO may not have standing. So for example, if they don't have any members that are within the region or the water body that you're talking about, is there a question that they can actually represent interests in that area? Another one is ripeness. This is a little bit less of a consideration when you're just talking about administrative and appeal. But for some, if they jump the gun too early, if there hasn't been a final decision made, or if it's not ripe because there's been no impacts from the project, that's something to consider, especially if they're bringing other claims like a nuisance claim that relies upon some actual negative impact from the project. And the last one is statutes of limitations. And that's a critical one that should be one of the first things that your counsel looks at when you're evaluating a litigation claim. Is there a statute of limitations on the claim? Have they met that and actually filed the case in time to comply with the applicable statute of limitations? For federal cases, that's a fairly lengthy amount of time. The Administrative Procedure Act has a 6-year time frame to file a case, but they might be much more limiting when it comes to a local or state approval. Next, specificity wins in all of these. That the more specific the environmental analysis, the more specific the science, will almost always trump sort of more general assertions. And this is where I think that The industry has an advantage because developing specific science and specific to your operation can be really influential and compelling to a court as compared to some more general studies or analysis. So, focus on project specific analysis to the extent you can. And that's why it's critical, I think, to develop some of that project specific environmental analysis as before the approvals are made. Focus on the region involved. If the analysis is done in your specific water body, in your specific state, tends to be more influential and compelling to a court as compared to the more general. Species specific over, again, more general claims. As you all know, species vary in terms of their environmental impacts. And so saying you've got an incredibly densely stocked mussel farm in Spain is a little bit different than a Pacific oyster farm in the Pacific Northwest that is stocked at far less density, and those environmental impacts will certainly be different. And then also think about previous precedent. Both previous precedent that the court has evaluated, but also previous precedent from the agency. If there's other environmental analyses that have been done before this agency or before or regionally, so you could sort of stand on the shoulders, perhaps, on some of the companies that have come before you if they've also developed a successful environmental analysis. Like an example here is, a controversial issue in Humboldt, California has been eelgrass, because they've got a very, very robust eelgrass overlay with aquaculture. And so over the last 10 years or so, there's been a lot of monitoring and mitigation and oversight to develop local science on the interactions between eelgrass and oysters. And so that's analysis that is project specific. And if you're a new farm in Humboldt Bay, you can rely upon that, even though you may not have had to fund it. The last tip I'd say is that speed is your friend. And this may be obvious. You want to get done with litigation as quickly as possible, so that you can hopefully win that litigation and move forward with like the things you want to do. Like just get out there and install and operate your farm. So how can you try to speed through the litigation? First, I would push for quick discovery. This is always something that opponents will try to drag their heels on. But when your status conferences come up with the court or developing a litigation strategy and scheduling, try to push for as quick of a discovery timeframe as possible. Unfortunately, a lot of courts are backlogged right now, so they tend to drag their heels as well, just from a case management perspective, but try to push for it as quickly as you can. The flip side of that is if you're going to push quickly for a discovery schedule that is fast, you also need to be ready to respond to discovery requests from opponents in a timely and quick manner. Don't give them the opportunity to blame your lack of responsiveness for an opportunity to delay. Also try to limit the scope of litigation. If there's multiple claims, see if there are some ways that claims can be dismissed early on through a motion to dismiss. And that will help focus both the court's attention and the discovery in the case that's involved in the preparation of an administrative record, and try to sort of speed through things without dealing with a sort of shotgun approach to just let's see what hits with 10 or 12 different claims. And then also most of these cases can be solved with a motion for summary judgment as opposed to going fully to trial. So try to develop a strategy that focuses on hopefully resolving things on a motion for summary judgment as opposed to a much longer trial process. There's also some post-judgment considerations. The order or judgment that's issued by the court, whether that be through a decision on a motion for summary judgment or the ultimate judgment in the case, is going to be really important. It's less important if you win, because the court will just sort of say, I think that the agency's done the right job, go ahead, and we don't have to worry about this any further. If you lose, that judgment becomes much more important because the court will remand it typically to an agency to follow its decision. And that judgment becomes the direction that the agency needs to take in order to comply with the court's ruling. And so that could be as limited as you need to change a couple of conditions here or there to you need to go back and restart everything, go back to the drawing board, or we're not going to let this project move forward, period. And so even if you lose, make sure that you're participating in how the judgment is crafted to make sure that is most protective of your project, and the things that need to be changed are as limited as possible, consistent with the court's direction. Secondly, attorney's fees. This is bad news. That usually environmental NGOs, if they prevail, will get their attorney's fees. In most cases, if you're defending an agency action, you will not get your attorney's fees, even if you prevail. Unfortunately, that's just sort of the way it is. There's a lot of people that don't think that that's necessarily fair, but that's sort of the legal system we're working with right now. Third, appeal. So know your standard of review if you do need to appeal. If you're going to appeal, it's much easier to appeal on procedural issues, things that the court may have sort of gotten wrong procedurally, as opposed to the substantive issues, because they're usually dealt with a different standard of review. And so know what your standards of review are for each type of issue you may want to appeal, because ones that get what's called a de novo review, which is basically a fresh review by the Court of Appeals, you may have a better chance of success, as opposed to a standard where they get a deferential review. If you do appeal, also know that there's also frequently a second opportunity for settlement there. Is there some way that you can sort of navigate or sort of split the difference between, well, we think we have a good chance in appeal, but let's try to resolve this now. Usually if they've won at the trial court, that'll be less obviously preferential than a settlement you get before that decision, but there nevertheless may be some opportunities to sort of cut it off at that point, and again, get you back to your farm operation and installation of your business. And the last one is, again, if you've lost at the trial court, make sure that you maintain that agency interaction and direction. If you do need to go back to the agency, make sure you're an active participant in how the agency is interpreting that ruling, as well as the follow-up steps that need to occur. A quick note on what if you are the one challenging the decision. So in this case, you're on the flip side of that. The agency's denied your approval. Again, I think that you just focus on the procedural errors and flaws. Those are preferential to bring to bring for a challenge in court, as opposed to the substantive decisions of the agency. So did the agency comply with its notice requirements, those procedural requirements? Did it go all the way through its own process, as opposed to sort of the substantive determinations on, say, environmental issues, where agencies tend to get more deference? Again, I know I'm beating a drum, but again, highlight the administrative record, highlight the things where your science hopefully could prevail over more general or erroneous citations to the record that the agency has. And again, highlighting the silence that you've developed as part of that process. And one thing to note there are times where, especially if you're facing an agency that's a political agency, like a planning commission or a city council or a county or something like that, do not assume that necessarily the ultimate decision will be that the agency finds in your favor. There are a lot of times, unfortunately, where the staff will be in support of a project and you're relying upon staff because it's all copacetic, it's all great. And then you get to that final place where the ultimate decider bends to political pressure in the community, and you get an adverse decision. And if you've been relying upon staff up to that point, then you're limiting yourself with the administrative record that'll be before you, because you now have an adverse decision. So make sure that you're developing that administrative record, even when staff is in support of a project, to sort of buffer yourself against that 11th hour change. And another question is it a taking? So that's an area that I get asked about a lot, which for years the answer would be no. If there was any sort of use of the property that remained, even in the case of a denial, the most recent Supreme Court decisions have actually opened the door more to a more nuanced analysis of takings, and whether or not an administrative agency's denial can open up the door to a procedural taking claim, to a deprivation of use of the property. So as you go through this process with your legal counsel, it's at least worth asking the question about, do we have a takings claim here that we might be able to seek compensation as a result. And then finally, know the agency's regulations and frame your arguments based upon those regulations. So, frame your arguments that they're not meeting either the procedural grounds that they need to comply with in their own regulations, or they're not meeting the findings needed to base their decision based upon their own regulations. So the last thing I'll talk about is Loper-Bright. Most of you will probably be familiar with this decision that came out of the Supreme Court last year. It was very well publicized, Loper-Bright versus Ramado, which basically dealt with Chevron deference. And without going into too much detail of the long history of this, because we're limited on time, I do want to talk a little bit about how this decision will impact the challenges to agency decisions. Basically, without getting too much of the details, it dealt with, a fishing regulation that NOAA had implemented, where they required the industry to pay for fishing monitors. And basically, the challenge that was presented to the Supreme Court said, well, they don't have the regulatory authorization to do that. The Supreme Court last year overturned was 40 years of precedent for what they call Chevron deference, and determined that courts must exercise independent judgment in deciding if agencies have acted within their statutory authority. So what does that mean? It says when a particular statute delegates authority to an agency consistent with constitutional limits, courts must respect that delegation so as long as agencies act within it. But importantly, as opposed to before, where if the agency had a reasonable interpretation, the courts would defer to it. The Loper-Bright decision decided that basically courts are the final arbiter of statutory interpretation, meaning there's only sort of quote unquote one best meaning of every statute. So a couple of important points about this. It only dealt with statutory interpretation, so statutes that are enacted by Congress, as opposed to regulatory interpretation of rulemaking that is enacted by the agencies themselves. So think about this like as, if you've got the Clean Air Act, that's enacted by Congress, but EPA regulations that are under the Clean Air Act, that's regulatory. So Chevron and Loper just concern statutory interpretation. They don't affect an agency's interpretation of its own regulations, at least currently, which is governed by things called the Auer and Skidmore deference that provides some deference still to an agency's interpretation of its own regulations. Certainly it's going to have an impact in a lot of different industries. It may have less of an impact on the aquaculture industries because a lot of the legislative statutes that the aquaculture industry relies upon, like the Magnuson-Stevens Act, those don't have a lot of cases that were actually decided under Chevron, with one notable exception, that the Endangered Species Act did have a lot of cases that were decided upon Chevron grounds, and that may be a more fertile ground for challenges in the future. So at the end of the day, this is going to breed some short-term uncertainty and more litigation as judges decide what the best interpretation of a statute is, but maybe a little bit more limited in the permitting context. There are a couple of cases that have come out that sort of reinforce these concepts. So courts will still generally defer to an agency's factual and technical judgments. Loper doesn't change that. So in other words, like for example, in the permitting context, how an agency goes about evaluating environmental impacts under NEPA, like an EIS, will still get significant deference. In fact, a couple of cases cited Chevron in the offshore wind context when challenging the NEPA and EIS NEPA regulations and the EISs that were developed under NEPA. And both the courts of appeals and the Supreme Court denied those challenges and basically found that Chevron doesn't change the deference that's provided for those types of analysis. This quote is actually from the Loper-Bright case itself, saying that although an agency's interpretation of statute cannot bind a court, may be especially informative to the extent it rests on factual premises within the agency's expertise. And actually, this case that just came out 2 months ago, when about 2 months after Trump became president, reaffirmed that, said Loper-Bright did not foreclose all reliance on agency expertise. So it's still to be seen as to how ground shifting that will be, but particularly when it comes to sort of permitting claims, it may not be that significant because agencies will still get scientific and policy deference for the environmental analysis, rulemaking, scientific and technical expertise, etc. And so LOPR right may be a double-edged sword in the sense that if you are defending the agency action, it may actually be harmful because the agencies may get less deference, particularly when it comes to their own statutory interpretations. Whereas if you're challenging an agency denial, particularly if it's based upon some interpretation of their own statutes, you may have a more favorable case to make in front of the court. And with that, I'm available for any questions. Thank you so much for the opportunity to present.
All right. Fantastic, Robert. Thanks a lot. We really appreciate your continued investment and engagement with NAA and for you just sharing some really expert insight into aquaculture. So thanks so much. That was fantastic whirlwind of information. Now's the time, folks. We have one question already in the chat box, but please don't be shy. This is your chance to speak with an expert attorney. So feel free to raise your hand if you'd like to speak up or go ahead and type those questions in the chat box. So Robert, we'll kick it off one from Lisa. Nordic Aqua Farms recently abandoned its land-based salmon farm project in Belfast, Maine, after years of litigation from local environmental groups and community opponents, which ultimately led to the project's cancellation. Given this experience, what red flags should aquaculture developers look for early in the permitting process that might signal potential litigation challenges?
Yeah, that's a great question. So I think that the previous presentation I gave last year sort of went into this in a little bit more detail, but I think that there's a couple that really stand out. I think early on, and this gets back to that question about standing and ripeness, you'll know in the permitting process who your potential opponents are because they actually need to exhaust their administrative remedies and be involved in that permitting process, usually to challenge it. And so you'll know your universe of your potential opponents. And a key question there is to evaluate how serious those opponents are, who they are in terms of their history with opposing aquaculture projects, and then also if there's any opportunity to resolve those concerns or considerations. And so, for example, if somebody that just writes a 2-paragraph email that says, I don't like this project. It can't be in my backyard. Please find some other place to send it. Probably not going to be a really significant or serious litigant against you at a later date. That being said, if there's another entity that has hired legal counsel, that is performing their own environmental analysis of those considerations, is supporting the administrative record against your interests, that shows a level of seriousness that I think should be a significant red flag that you might be dealing with a potential litigant. Obviously, I think absolutely critical to try to alleviate those concerns and reduce the potential for ultimate litigation opposition is, site selection is critical, outreach is critical, and being flexible in trying to resolve some of those concerns to the extent they can during the permanent process is really important. And none of this is a criticism or a specific comment to Nordic Aqua Farms specifically, but during that process, you should be able to identify, who your potential litigation risks are, and hopefully develop your legal strategy before permit approval accordingly.
Excellent. Okay, our next question, could you speak a little bit more about when projects may be able to continue to operate even when their litigation is underway?
Yeah, and so very generally, this can vary from state to state, but yeah, the general basis is that you are allowed to operate as a permit is being challenged generally. There are some exceptions, and you should make sure whether or not that's acceptable, especially on the local or state level. But generally, you're allowed to proceed unless the opponent gets either what's called a temporary restraining order or preliminary injunction, which they'll need to get court approval on those issues. And so the legal issues that are involved generally in that are what is the harm that's going to occur if the permit is allowed to proceed, and what is the likelihood that the opponent is going to be able to prevail in their ultimate litigation claim. And so it's going to be really important if you are facing litigation and that preliminary injunction motion comes in or a TRO comes in, that you be really active in defending against that on both of those grounds. So for example, for aquaculture projects, it can be a successful strategy to say, well, listen, we have a lot to do before there's going to be any impact whatsoever. We're just at the very preliminary stages of our implementation of our project. It's going to take a while to ramp up. Even when you ramp up, these are just small creatures in a lot of cases that need time to grow. There's a lot of things, if you have a phased implementation plan, that can also be a compelling case that there's not going to be a significant amount of harm. So you're going to want to combat it both on sort of that impact level, as well as obviously in the legal case against you. So hopefully you can defeat a case for preliminary injunction, which would allow the process to continue up until a court decision, which is obviously really important when you're trying to avoid an interruption to your farm.
Okay, we've got a follow-up from Lisa. Are you aware of other aquaculture products like Nordic that encountered significant legal opposition during permitting? And I'm curious if there's common patterns in those cases that developers can learn from.
Yeah, unfortunately, I'm aware of dozens of cases of opposition, throughout the country, and I would say that it's unfortunate that right now, I think that there's the opponents of aquaculture over the last decade plus have become much more organized over social media, and with some organizations that have helped coalesce their efforts. And because of that, you do have some themes that have been replicated nationally in a lot of these cases because they deal with sort of national organizations that are seeking to deny aquaculture permits. And so I think in terms of general themes, I think that there's probably 3 or 4 that rise to the top. We've seen the national organizations try to work with local entities to oppose aquaculture projects. So even though these national organizations may not have a specific tie-in to a farm or a region, they've partnered with local NIMBYs, like property owners, not my backyard folks that do live in the area that don't like it for aesthetic purposes or other purposes, or fishing organizations and associations that have concerns about aquaculture generally. And so there's sort of been a partnership there or an intent to try to represent those interests in opposition. Also, I think while aesthetic concerns tend to be the most predominant consideration for most opponents, those aren't necessarily seen as a compelling interest to reject a project in a lot of cases. So they'll masquerade those considerations for environmental considerations, whether those be to fish species or to seagrasses, et cetera, trying to frame their arguments on ecological considerations has been obviously a prevailing theme. And then I think that there's also been an effort nationally to try to challenge some of the overarching federal permits, whether that be in the Gulf, when the Gulf NOAA tried to set up its own federal permitting process down there, to my home state of Washington, when they successfully challenged and invalidated Nationwide Permit 48 when it came to Washington, to their continuing efforts to oppose, sort of programmatic approvals for offshore aquaculture, including finfish. Those are efforts that I think that most aquaculture opponents are trying to be focused on a case that tries to deal with an umbrella. So, for example, if you invalidate a nationwide permit that applies nationwide, it's a lot easier of a target than trying to go against individual farms or permits specifically. So I think there's been a focus on trying to address those in terms of overarching considerations for permitting processes, as opposed to the individually specific farms.
Okay, and a pretty good segue actually to our next question. What are your thoughts on NOAA's draft programmatic environmental impact statement for Southern California aquaculture opportunity areas? Will that help enable projects, or will it also be vulnerable to litigation?
On this one, I'm going to have to be a little bit circumspect because I actually represent a client in that case. Uh, so let me just sort of frame this generally. I think that, and this is my own personal opinion as opposed to sort of my opinion for my client or for K&L Gates. I think that if it comes to fruition, I think that it actually can really, really help in Southern California. I represented a number of companies in California specifically, and what the common refrain you hear from everybody is that it's too expensive in California to establish aquaculture, and you've heard that from everybody from the smallest companies that would like just to get a foothold there, to the regulatory agencies involved, to the larger companies as well. And I think it's true. California has some unique circumstances that do make it more difficult to establish there than some other jurisdictions. And I think that the general premise of the Southern California AOA, which is to do some of that pre-planning and the environmental review and develop a defensible EIS, could ultimately reduce some of those points of cost of points of entry, because some of that work will be done, hopefully. And we're certainly looking forward to the finalization of that process and adoption of a final EIS. At the end of the day, as NOAA will be the first to say, that still requires you to go through a permitting process at the back end of that, which is still significant. But my own personal opinion is that I think it's a step in the right direction, and I applaud NOAA for continuing to work on it. I do think that it's interesting. There were a significant amount of public comments on the draft, a number of them in opposition, primarily. There are a number of opponents that I think are sort of common in these cases that submitted some comments in opposition, primarily on the finfish part of the AOA. And so we'll see how NOAA deals with those comments. But when it comes to litigation risk, there was some of those comments would certainly raise a red flag that that's at least a possibility.
Okay, we've got two more questions in queue. So it's understandably very difficult for offshore aquaculture projects to raise any significant financing until the permits are in hand. Yet anti-aquaculture activists are usually well-funded and are incentivized to pursue all legal options, no matter how thin. How do you recommend that project proponents try to address this quandary?
Yeah, it's a really, really tough problem right now because when you're looking for financing in offshore aquaculture, it's sort of the chicken and egg issue. A lot of financing is sort of not stepping up because there aren't a lot of aquaculture projects that are out there. But if there were some that were successful, then that might provide or loosen up financing for more. But you have to have those first couple that are in the water that are successful. That could sort of be the proof of concept, and that certainly has been a difficulty. There's been obviously some options, some good progress done in Maine on test projects. There's some that are going forward in Florida, but none of them quite at the level of what we consider to be sort of commercial proof of concept. Although I think that the folks that are industry are optimistic they can get there. I think that it's an inherently difficult issue. I think that the AOA process could be a part of a solution there, because if it is successful in providing a robust environmental analysis that can be tiered off of, then as opposed to doing an EIS that could cost over $1 million, and you could do an EA for maybe $100,000, then maybe at least a partial solution to resolving some of those financing considerations. But at the end of the day, right now, I mean, if you talk to folks like Don Kent that have been involved in the process for years, I think it is a fairly daunting process at the moment. I think that were we able to get federal legislation, which at this point is going to be difficult to do, to try to clarify some of those property ownership considerations, especially in federal waters offshore. If we got a successful AOA process that could be that was legally defensible and successful, that would go a long ways. And I think that there's going to have to be hopefully a couple of projects that come out of these initial proof of concepts that can help further develop the science that then can be replicated and used by larger proposals. But I think at the end of the day, and this is not best for financing considerations, but a phased approach, which you start with a relatively smaller project and develop that proof of concept, and then build up your farm from there, is going to be an approach that is probably going to be best to be successful. And I think there are some in the works that are working through that process that hopefully are going to be successful in that endeavor.
All right, our next question. Let's see. Three bills were proposed in the Oregon legislature this session targeting aquaculture: a net pen ban, an octopus farming prohibition, and an eelgrass task force bill. Despite there being no activities like these proposed farm types in Oregon, how might these regulatory trends influence aquaculture development strategies? Are there legal precedents or patterns that developers should be aware of when planning projects in these regions?
Uh, the short answer is yes, but it does depend on, well, I think two things I would say there. Even if there aren't projects that currently are affected by those, I track that legislation closely because other things can creep into it when through the amendment process where they do encroach on areas that may be more germane to operations in a state like Oregon. But those are, issues that have been reflected in other states with some, relatively drastic consequences. So, Oregon is following Washington's lead in its banning of net pens in state waters. That's something that was announced by Washington State Department of Natural Resources after some significant controversies that happened with the net pen escapement in Washington, and that's been something that's unfortunately been a pretty predominant theme along the West Coast. And once that is enacted, I think that's if that is enacted, it's going to be very, very difficult to sort of unring that bell. And even with the development of good science, to the contrary, just politically, it's difficult once that's enacted to undo it. For eelgrass considerations, having that experience in California with the California eelgrass mitigation policy, it's been, my own personal opinion, while eelgrass is a critical resource, certainly no one doubts that it is a vital, significant habitat. The way that the policy has interacted with the science, I think has been a little bit discouraging in the sense that, since its enactment, there's been a really robust development of sort of science when it comes to interactions with aquaculture and eelgrass. And that's an issue that, where the policy has sort of been stuck in the mud or hasn't been able to be improved and updated based upon the science that's been done since its original enactment. And so that's a concern, for other states as well, that if you have a policy that's based upon current science and legislation that's based upon that, how is that legislation and policy able to adapt if there is future science that may be contrary to sort of current considerations? So definitely those are things worth tracking.
Okay, well, we're almost out of time. If anyone has one final question, great engagement today, folks. This was a great Q&A discussion. I think I'll take it just a minute, shift gears a little bit. So the National Aquaculture Association, our staff, board of directors, a variety of our members we're broadcasting this webinar live from DC this week. So we're all up in DC, primarily advocating for the Farm Bill priorities again for U.S. aquaculture, and of course meeting with a variety of federal agencies to continue our advocacy efforts to streamline regulations. And regulatory reform is a big part of what's going on right now with the current administration. The Office of Management and Budget, OMB, recently put out a call for soliciting interest from what regulations could be cut or removed from the FCR. I wanted to see, Robert, what your thoughts on, if you could give us a little bit of what may happen in the case, unintended consequences of this, where we're removing federal code of regulations, but we're not necessarily seeing legal or statute reform.
Yeah. So we've been pretty engaged in this process. K&L Gates is one of the few law firms that has a robust lobbyist practice in Washington D.C. As well as our the more traditional law firm practice. And so I've been engaged pretty closely with our D.C. counterparts and partners to talk about how this is happening on a day-to-day level, because it really is changing every week, every day of this administration, as you're all aware. I think there's sort of three issues that really sort of jump out for the aquaculture industry. One that I think has been very significant has been the Doge cuts when it comes to employees and agency staff. That's been, I think, unfortunate and has not benefited the industry overall. Certainly there's opportunities for more efficiency. There's more opportunities for regulatory efficiency. But at the point where you're cutting staff and not enacting those regulatory changes to make it more efficient, you're more or less just taking people out of jobs that they still need to do. The aquaculture, industry still needs permits, and as of right now, those permits are still required. And so, with staff cuts, I think you've got a significant possibility from NOAA and EPA and others that it's going to actually slow down the process. Secondly, I do think it is an opportunity. If there are regulations that the industry believes aren't needed, this is certainly an opportunity where the Trump administration is asking for those ideas. They've got their 10-for-1 deregulation initiative, and an agency like NOAA is struggling to find ways to cut 10 regulations, and they do need new regulations in some circumstances. So if there are areas that you do think that there's opportunities for efficiency, this is a unique opportunity to engage with your legislative representatives and agency representatives to take advantage of that opportunity. But third, I do think that generally it also creates some significant legal risk. I think that there's going to be, and there already has been, a significant amount of legal opposition to some of the Trump's regulatory initiatives, and especially ones that are seen as improperly cutting out procedural steps for approvals. We anticipate that will likely continue. And so I would just be very cautious if you are a company as seeking to take advantage of some of these regulatory shortcuts, that you think through that as to whether or not it's worth what may be a significant litigation risk, or be embroiled in some uncertainty as those sort of regulatory or deregulation initiatives get worked out in court.
Okay, and we'll finish up. Tony had one final question, Robert. If you'll, I know we're a little bit over time, but this is a great discussion. So,
Sure.
there are examples of successful aquaculture operations worldwide. Are there any concerns using these for a proof of concept? Will it bring out the bad examples?
That's a great question too. I think that it depends on the type of aquaculture that's being proposed, and the region that is being proposed. I think that at the end of the day, on things like operational consideration, logistical considerations, engineering considerations when it comes to type of aquaculture being proposed, and offshore aquaculture is a great example of this, because the worldwide offshore aquaculture is not that uncommon, is definitely uncommon in the United States. And so almost by necessity, you need to look to international examples to identify some of those proof of concepts and the evidence of a functioning system that works. And I think that you do see some agency deference on questions of engineering considerations and operational ones. I think that's still going to need that second level of analysis on environmental considerations and other things like how a specific system will interact with the surrounding environment, done on a local level to get agency approval, and also to sort of build that administrative record for a robust defense and litigation.
All right. Well, I think, folks, we're going to wrap it up with that. Robert, thanks again. This was really great. The National Aquaculture Association provides these webinars as a really a free resource that are focused on topics that really matter to farmers and aquaculture businesses in the U.S. We hope everybody's getting a lot of value out of that. And I just really encourage everybody to, whether you're a farmer or a supplier or a public service member, please join the National Aquaculture Association. We are 100% funded by our membership, and we really need everyone's support to continue our success story in DC. So with that, we will just a little bit of a teaser for next month in June. We actually will have two NAA webinars. So the next one's going to be NC State University's coming to speak about value-added seafood processing for aquaculture. And then we'll also be featuring the Soy Aquaculture Alliance at the end of June for an update on all of their research efforts. So we hope you continue to find value in these webinars. Please reach out to us anytime if you want to get in touch with Gulfstream Aquaculture, our sponsor, or Robert. So with that, we'll close it out for the day. I hope everybody has a great rest of your week.
Thank you.
Bye, everyone.